Okay, we're gonna start. Okay. That was somebody who wanted us to start.
No problem.
Okay. Hello, everybody. My name is Linda Taylor, in case you don't know. And I'm fortunate enough to be part of the Blue Zone Project Health Series. And I'm happier to introduce you to Claudia De Jesus, who's the managing partner of Mattar law firm, which specializes in elder law. Annalie Kruger, who was here last month, is also coming from right here. So she hit a traffic jam. So we're going to let her organize, but Claudia will start. Here, this is yours. And so here she is. And then Annalie will also join her. So here we are.
So Ashley is over there, the blonde, and so that's where we got the Ashley Kruger from, right? We have Ashley, Annalie, and Claudia. Thank you for having me today. My name is Claudia De Jesus from the Mattar firm. As some of you might have seen our advertisements on television, we always talk about the workshop that we give, which you're going to receive today. And we focus on asset protection, estate planning, elder planning, and also Medicaid planning. Is there? Oh, let's see. Let's see if the microphone is on. No. What about now? Is it on now? Yes. Okay, wonderful. All right, so before we get started, I want to tell you a little bit about my firm. I want to show you what you have in your handouts. So each and every one of you should have a pamphlet. It's a booklet, and that's going to have information about the stories that we're going to tell during this workshop. I don't want you to worry about remembering all of the information. We're going to anchor back to these stories, but that pamphlet, the little book, is going to help you walk through the workshop by reading, right? In your folders, so every one of you should have one of these folders, which will serve as a large business card if you need to get a hold of me, okay? In your folder, we have our evaluation. You can give me all fives now, or no, I'm just kidding. But we really do want to know your honest opinion. We give workshops weekly, and so I really value your criticism. So if you could fill that out, this information stays private, and that way we will be able to anchor back to this to become better at what we do. There is a photo of myself and Mr. Bill Mattar. This is going to give you a little bit more information on why we went into estate planning, what our law firm's goals and mission are. We have some estate planning misconceptions, and this is really great because a lot of people think they know and that they know what they need to know, right? And so they're always shocked when they sit through our workshop and they say, wow, I didn't realize that. I didn't know that. We also have our 4 steps. So we break our estate planning process into 4 steps to make it easy and so that our clients don't feel overwhelmed or bombarded with information. So first, we always encourage clients to attend the workshop. So that's what we're doing here today, right? Next is your vision meeting. So that's what you're going to call your consultation. Those are complimentary to everyone who attends our workshop. So every single one of you here today and online will be entitled to a consultation with our office, and we're going to call that your vision meeting. Next is our design meeting. That's where now you've said, okay, I want to engage the firm. Let's start creating my plan. And then lastly is your signing meeting, where we execute your estate planning documents and we move forward, okay? There's some more literature in there for my fact finders, for those folks who want to keep reading up. And last but not least is our asset protection worksheet. A lot of the analysis that you're going to hear me talk about today anchors back to the type of assets you have and how they're invested. Is it a 401k? Is it an IRA? Is it money in the bank, right? And so this worksheet, we're not asking for account numbers. This is just asking for round figures so that we can go ahead and give you your analysis. So this is something that we ask our clients to fill out ahead of time, but if you feel uncomfortable doing that and you'd rather just do it verbally when we meet, that's also fine as well. Okay, all right, let's get started. So we call our workshop How to Protect Your Stuff in 3 Easy Steps, because we really want to break this down for you. And after the workshop, we want you to be able to knock it out at the vision, design, and signing. All right. So again, this is in your folders. What are we going to learn today? We're going to learn how you can protect your assets. We're going to start with the foundation of estate planning, because a lot of people like to just jump to the will, right? Or jump to the trust. And we need to make sure that you have your main directives in order and in place before we start talking about a will or a trust. We're going to talk about what a trust is and the difference between a revocable and an irrevocable trust. We're going to explain to you what trust is going to protect you, because there's a lot of misconceptions about the trust that actually protects your assets from creditors and also from liabilities and, of course, the cost of long-term care. We're going to discuss if you should be giving assets away and what that means when you make these gifts, right? We're going to talk about those main directives like a power of attorney, healthcare proxy, and living will. We're going to talk about how you can plan for your disabled beneficiaries. A lot of my clients will sit down with me and they'll say, I have a loved one who has a disability, so I can't leave anything to them. Well, you can. We just need to make sure that we do it in the proper way and structure that properly. But that is a far better way than just saying, oh, I'm going to leave it to Joe and I'm going to hope that Joe provides for Sally. So we'll talk about that. How do I avoid estate taxes? Does that affect me here in Florida? And is there anything else anyone came in here really wanting to know? No? Okay. All right. Okay, so the goals for us that we have for you are for you to identify. We want you to leave here today saying, okay, I know I've got that. Maybe I have a couple questions. And when we sit down at your vision meeting, I encourage you to bring with you any previous estate planning documents, whether you drafted them last year or whether they're from 1985, let's review them, okay? We want you to feel like you're all set. I think that I'm most comfortable when I understand the worst case scenario, right? What's going to happen in this event? And when that's all spelled out for me, I feel really comfortable. So that's what I like to do for my clients. Hey, if this happens, here's the road you're going to go down. So we're going to illustrate that all for you at your vision meeting. All right, so 3 steps to planning and protecting your estate. First, we have to know the rules. Next, we have to know who our creditors are. And even though we might not have creditors or we might think that we don't have liabilities, we all do. And then we have to know our options. So what are the rules? So essentially, when you don't have an estate plan, you're defaulting to the rules of the state that you live in, okay? So you're saying, hey, Florida government, whatever it is that you've decided for me, that's what's going to happen. And so in order to take that control back, right, and be able to call the shots on what happens while you're alive and well, and then also if you're alive and incapacitated, you need to have your basic estate planning directives in place. So what I want you to ask yourself is, have I given someone authority to act for me legally in my absence? And a lot of folks will think, hey, I'm married, so my spouse naturally has this authority, or my eldest child will step in. You really need to spell these things out in your estate planning directives, especially when we have blended families, especially when we just have, maybe you've been married for 40, 50 years, but kids and spouses, things can get tense under tense situations. So we really want to make sure we've got that spelled out. Have I given someone authority to make my medical decisions for me? Again, don't just think that your daughter or your spouse is going to be able to do that. Another thing that we're going to discuss is, if you are married and you have a spouse, who are these people if something happens to the both of you, right? Like a car accident. So a lot of times I'm presenting these like doomsday scenarios that I don't, want to bring up, but we have to just to make sure. So go ahead, sir. Yes, exactly. You got it. So we're going to go into that on the next slide. So that's exactly right. So who's going to make my legal decisions for me? That's going to be my power of attorney. Go ahead, ma'am. Yes. Right. We'll talk about that. It shouldn't be there. And that's a great segue into what Annalee is going to speak about as well. You see those right there? So, but that's exactly right. So I'll anchor back to that in a second. The power of attorney. So who's going to represent me legally? Who's going to step into my shoes? And who is going to be able to make financial and legal decisions? This is not your executor. This is not your personal representative. And this is not your trustee. Okay? It can be the same person, but just because they have that designation doesn't mean they're your power of attorney. The way you want to think about it is, first of all, we have to remember that we have to set the foundation while we're alive. A lot of clients will come to me about a will. I'm like, I'm not really worried about when you pass away. I want to make sure you're good while you're living, right? So your power of attorney is valid while you're living, and then it passes away with us, okay? So it's no longer good once we're gone. So when clients come to me and they say, well, I have an executor, I have a personal representative. Well, think of it as a relay, and that doesn't trigger until you're gone. So the power of attorney is really critical so that if you're disabled or temporarily incapacitated, someone can act for you, sign off on your legal documents, any type of financial documents as well. In your power of attorney, you don't just want to appoint one person. We always want to have backups. So at any time that you come and sit down with the Mattar firm or really any estate planning lawyer, they should encourage you to at least appoint 1 or 2 backups. And when clients come in with 4 backups, I'm like, great, that's fine. You know, let's make sure that if you're taking the time to do your estate plan, let's do it right so you don't have to go back to the drawing board, okay? And when you approach your estate plan, yes, you can make changes later on, but you want to approach it as if you're planning for tomorrow being the rainy day, okay? So you want to make sure you've got all those triggers in place, and we'll do that for you. We'll make sure of that. Your healthcare proxy and living will. The healthcare proxy is who makes your medical decisions, all right? So who decides if I'm going to be intubated, okay? Who decides if, you know, this certain medical procedure is going to take place? And the living will accompanies that document, and the living will lets your medical proxy know what those decisions are. So how you feel about life support, what, you know, I've had certain clients with certain religious beliefs, they can't receive blood transfusions. Things of that nature, no one's going to know that unless we make sure to place it into your directives. So what happens if we don't have these in place? Well, what's going to happen is that there might be a guardianship proceeding. And guardianship, it is not fun. It basically is your loved one having to petition the courts to be appointed to have that authority. And when the courts get involved, if there's any turmoil between the family, a third party may get appointed. So that now means a stranger could be making those decisions. Remember that now we're in the court system, now we're dealing with fees, right? So it's costing us a lot more in the long run. And it's just so easily avoided if we just take the time to make sure we have these in place. So that's really, really critical. All right. So what happens after we pass away? That's where our will comes into play. So remember, whatever directives you have in your will, those have nothing to do with you while you're alive. So you could have appointed, you know, Joe as your executor. Joe doesn't have authority until you're gone, okay? And your will, when we talk about a trust, a lot of times clients will say, well, what's the point of the will? Yes, the will can be a formality. When you have a trust, your will is going to make sure that if you've left items outside of your trust, let's say you bought a CD at a bank, you forgot to title it to your trust. Your will is going to make sure that it goes into the trust, okay? But for those of us that don't have a trust, we still need a will. Why? Because it lets the courts know, it lets the judge know where you want your assets to go. Another distinguishing feature that a lot of clients are surprised about is that you might have certain directives within your will, but if your accounts are beneficiaried, the will not apply, okay? So whoever your beneficiaries are, that's what goes first. So we'll talk about that, especially when we meet one-on-one, on how that plays into certain family dynamics, because you might have set rules in your will that you want to be followed. And if you've now got your account beneficiaried to the wrong person, those rules aren't going to apply. So I will show you how that all plays in. Another common misconception is that by having a will that you're going to avoid having to go through the court system and having to go through probate. But every will gets probated, okay? So what is probate? Has anyone here been through the probate process? All right, sir, would you say it was fun? Would you say no, right? Oh, well, bad example. No, I'm just kidding. In English probate, I would love to hear about that. But probate typically here in Florida takes about 6 months to a year. And especially now with COVID, we've had some probate cases that were going to be resolved and the court shut down and everything just gets pushed and pushed and pushed. And now we're at about 1.5 years, right? And so the way you want to think about it is I have a house, I'm on the deed to that house. I've left my house to my daughter or my son in my will. How do they get it? They have to go through probate, okay? That process is going to take them time. Who's paying the HOAs during that time? Who's paying the electrical, right? Who's keeping the house up? So avoiding probate is one of our top priorities for our clients because it's just such a tedious process. It really frustrates family members. And so we can easily avoid it. We're going to talk to you about how you can avoid it through a ladybird deed and through a trust and having those beneficiaries listed. But what I want you to take away from this is that if you only have a will and you're leaving property behind, that property is going to probate. So we'll talk to you about avoiding that. So just know that the will is necessary, but unfortunately it does not resolve our problems when it comes to estate planning. Yes.
So there's actually a way to avoid going to probate for property.
Yes. Yes. Here in Florida there is, okay? And so that's what we call a ladybird deed. Yes, sir.
Is that typical throughout the 50 states?
It's not. So that's why when we have clients and when we sit down, if you have property in multiple states, a lot of times a trust is going to be necessary. If not, even if you've taken care of the Florida property, if you've got, let's say, a Michigan home, well, now they have to start probate in Florida just so that they can get clearance to start probate in Michigan to get your house there. So ladybird deeds apply in several states, but not all 50. All right, so what we want to remember is that we can't just have our directives, come offline. You want to make sure that you've got the right power of attorney, the right healthcare proxy. I'll get to you in a second, ma'am. And so the power of attorney for Florida, it's very specific. It has specific statutory language. It has superpowers, and you need to understand what you're initialing off on. So we really like to make that distinguish between, hey, let me just get this document offline and get it notarized. And you really want to make sure that these directives are executed in the proper manner. Yes, ma'am. Oops.
If you have to transfer on debt
Yes.
as the beneficiaries, 2 accounts that you have,
Mm-hmm.
did I understand you that takes precedence over the will?
Correct.
Okay.
You did. Yeah. So, for example, the scenario.
For the people online, could you repeat the question?
Yes, I'll repeat the question. So the question was, if I have transfer on death beneficiaries on my accounts, does that take precedence? Does that apply versus the will? And the answer to that is yes. And so where that can become a problem is, let's say you've come to me and you've said, I want to leave $50,000 to my daughter, Mary, but Mary isn't a very good spender. I'm scared she's going to squander that, right? If you've left provisions for how you want Mary's money structured in your will, but if Mary is the beneficiary of that account, those provisions are gone. Mary's going to get that money outright. So it's really important that we sit down and we understand. And so a lot of times that's why a trust will be ideal, because you can say, hey, I'm going to leave it to the trust. We're going to avoid probate that way. And then once it's in there, now my loved one has to follow these rules. So we'll be able to talk about all of that as well. But does that answer your question? Okay, perfect. All right, so who are our creditors? I'll sit down with clients and they'll say, I don't have creditors, I don't have liabilities. Well, we all have liabilities in terms of what can come towards us, right? We can have any type of lawsuit. The government can be predatory in the sense that if we fail to structure our estate plan properly, our loved ones might have higher taxes. If we fail to structure our estate plan, the government might get involved in terms of guardianship. The cost of long-term care is predatory as well. We're going to talk about that. Your family can be predatory, right? Sometimes we have to protect ourselves from certain family members or protect certain family members from others. So that's part of your estate plan as well. And then of course, protecting ourselves from lawsuits. So of these 4 predators, which do you as an audience think is the biggest threat to your estate? Your family. Yes, long-term care. Yes, you're right. The cost of long-term care. That is rising by the day and it's not going to go down. So we need to understand that even if you have millions of dollars, planning for long-term care is really, really critical. It can cost about 120 grand a year, if not more. So it's something that we really need to think about no matter what our financial situation is. All right, so again, how can the government be predatory? I don't want them deciding what happens to me if I have a medical issue. Probate as well, and then taxes. How is long-term care predatory? Right now, long-term care, and that number actually went up, but it's costing around, let's call it $10,000 a month, okay? Long-term care, we have to get away from the notion of thinking that long-term care is a nursing home and that long-term care is only going to be 2 years, okay? Long-term care is an umbrella term, and it includes stay-at-home care, assisted living, memory care, and full skilled nursing. So what we're seeing in this area is that a lot of people are suffering from memory care issues, but their bodies are not deteriorating at the same rate as their mind. And so the whole notion of thinking that you're only going to need care for 2 years, that really doesn't apply anymore. We see folks needing care for 5, 6, 7 years. So that can become really detrimental to your family if it's costing 100 grand a year, okay? So we're going to show you how you can protect. All right, so what happens, right? Essentially, when you think of long-term care, I want you to think of 2 roads, okay? You're either on road 1, where you're private paying, which means you're paying that $10,000 a month, that $120 a year, or you're going to be on road 2, where you contribute your Social Security, a portion of your income, and you're able to get Medicaid. So let's dispel a couple myths before we start using the term Medicaid, because it can be a little shocking to folks. But Medicaid does not mean that you don't have assets, okay? It's very important that you understand what the asset allowances are in Florida in order to be able to receive Medicaid, and understand what's protected by the state naturally. Because guess what? If you turn over a protected asset, they very much will take it in terms of allowing you to liquidate that, but you don't have to. So what we're going to talk about today is what are those protections? We want you to have those tools. And what isn't protected, there is still a strategy for how you can protect that with the proper trust. And we're going to show you how you can do that. So I want you to think of all of you as having a bucket, right? You've got your assets in that bucket. Naturally, Florida protects a couple of them. And then what isn't protected, we're still going to be able to save, okay? But first off, Medicaid. Who has heard that Medicaid can take your house? Okay. Who has heard that you have to give all of your assets to someone, put them in your children's names, okay? And that once you do, you're going to have to wait 5 years. So those are all myths. They apply. The first one can apply in some states, but not in Florida, thankfully. The second one is actually a myth. You do not want to give assets away. There are certain allowances that you're allowed to have, and if you give away that allowance, so for example, Medicaid allows a married couple to have 130 grand. But now if that married couple gifts that money to their child or their grandchild, now that's a problem. So we really want to understand what do we have that's protected And what's going to happen if I start making these gifts? And then the 5-year rule, that is something that is just commonly misunderstood. The 5-year rule is a look back period. So there's no avoiding it in the sense that we're all going to go through it if we're looking to get Medicaid. But it does not mean that we wait 5 years. It just means that they're going to ask us about the last 5 years. But remember, there's things we're allowed to have. So for many folks, they qualify for Medicaid immediately, despite having assets. But what do they think? They think they need to wait 5 years, and it can cost the family a lot of unnecessary money. So we're just going to advise you as to what the law is. All right. Medicaid is also very complex. It changes twice a year, and it's different in every state. So for my Northerners, I think I have one Western New Yorker over here, right? The Medicaid rules in New York are very different than the Medicaid rules here in Florida. So leave behind your notions of what you knew from up north or what you might have gone through with a family member up north, because it's not going to apply here. All right, for our family predators. So a couple situations where we see that is we have blended families. So some of the scenarios that we often work with is, hey, I have this spouse. I want to leave an asset to my spouse, but I wanted to route back to my kids from my first marriage. Not a problem. That's easily done. Okay. If we ever have a remarriage, so for example, hey, I want to leave assets to my spouse and my kids, but now if my spouse remarries, I want to make sure the money I've earmarked for my kids is safe. Easily done. Okay. If you have children or beneficiaries that are spendy, right, and we want to set rules for them, or maybe someone struggles with an addiction issue, we can work around that. Okay. We do these things all the time. Again, if someone has a disability, you can leave them assets. It just has to be structured properly. And that's going to be much better than just cutting them out and hoping someone takes care of them. A very, very popular one is protecting your beneficiaries from divorce. Obviously, you cannot prevent someone from going through a divorce, but what clients will often say is, hey, I want to leave this asset to my child or my beneficiary. I want to make sure that their spouse doesn't get it. And that's perfectly fine. So at the Mattar firm, we're going to make sure anything you leave your children or your beneficiaries stays within your bloodline. Or, hey, if that child is gone, maybe it goes to your grandchildren or another family member, to make sure that it doesn't leave with a spouse when the marriage dissolves, if that happens. And then lawsuits. So I used to practice personal injury law, right? And so what happens when you're in a car accident? You're scared of getting sued. There is a way to protect yourself from that. Okay? All right, so what are our options? So those are our predators. That's what we need to know that's out there and we can work with. So our options are basically having your proper estate plan. You need to make the following decisions. Your estate plan really should address what's happening and who's in control while you're alive and well. What is happening and who's in control while you're incapacitated, okay? What's happening and who's in control when you pass away? What if you pass away and you're a caregiver? Okay, so what if you're caring for a spouse or a loved one and now you're gone? We need to make sure we've accounted for that, right? Who's going to step into those shoes? What if your spouse is disabled? What if your spouse passes away? What if, they remarry? All right, this all affects your estate plan. And then your children or whoever you're leaving your assets to. What happens if they become disabled? If they pass away, where does it go? And so it's not something that you need to worry about answering right now, but these are issues that we're going to touch upon when we meet. And clients will sometimes say, well, forget it, let the kids decide where it goes after that point. And I'll say, no, this is what you worked hard for. These are your assets. You get to call the shots on that. So that's really important to remember. And a lot of times what I'm told is, Claudia, I want to stay in control. And I fully respect that. So we always want you to be in control. We want you to be in the driver's seat at all times. And the whole point of having your estate plan in order is so that you've decided who's going to control in your absence. Okay. All right, so again, remember the one-way road where we're not doing anything and we're gonna just private pay if we're in a bad situation, or we can plan and prepare. That's gonna be your two-way street. So let's talk about it from the perspective of your biggest threat, which is the cost of long-term care. We're gonna go into a couple case studies and a couple stories, and we'll be able to go from there. All right, so let's tell you about the Smiths. So Mrs. Smith is she was healthy. She wasn't thinking about needing long-term care, all right? She didn't think that that was on the horizon, but she had a fall and she broke her hip and she needed rehab. And so when that happened, Medicare was initially paying for her bills, right? Because she had a fall, she had, surgery. They took care of that. But what's a common misconception is that Medicare will pay for up to 100 days. Well, they very rarely do that. They can cut you off whenever they deem reasonable, okay? That's what happened to Mrs. Smith. She was in rehab care, hoping to come home when her husband receives a bill for about $10,000, right, from the rehab facility. So he's thinking, okay, time for her to come home, right? And he realized he didn't have, care for her in case she fell. He couldn't pick her up in case she fell, the proper shower. So it became really real to him that in order for her to really improve and heal, she needed to stay there for a couple more months. So this is where he starts meeting with his daughter and he says, at $10,000 a month, we don't know when mom's coming home. This could cost us a lot of money. And so their daughter said, let me talk to a couple attorneys, see what we can save, right? See how we can get mom on Medicaid so that she doesn't have to pay that $10,000 a month. So let's talk about their assets. Remember, Mrs. Smith is now in the rehab facility, so she's knocking on their door, right? On Medicaid's door, let's call it that way. So she's gonna go through the look back, but watch how she does not wait 5 years, okay? She has a house. And so when I'm consulting with her daughter, I say, Mary, what did the lawyers you talked to, what did they tell you about the house? She said, they said the house is safe. I said, that's right. All right, in Florida, whether you're married or single, you can have a house and still qualify for Medicaid. This is one of the biggest allowances, all right? In other states, single individuals are not allowed to have a house. They'll put a lien on it. But in Florida, you can. So what's one of the biggest mistakes that I see every day? We sold mom's home. Great, you've just taken a $200,000 asset that was protected, and now you've turned it into a pile of money that we're gonna have to give to the facility. So the first thing that my staff is advised to do anytime someone calls our office and says, we're gonna sell, do not until you sit down with a lawyer. You need to understand what that means if you're liquidating an exempt asset. That can be really dangerous. So in this scenario, they have a house, that's in the green, that's good to go. They have a car. And so you're allowed to have a car on Medicaid. So Mary says, yeah, the lawyer told us we could have a vehicle. I said, that's right. Cash, they had $105,000 in cash. And I said, Mary, what did they tell you? She said, they told us it was safe. Correct. In Florida, a married couple is allowed to have $130,000 in cash and still qualify for Medicaid, okay? What's the problem? If your spouse passes away, so if Mr. Smith passed away while she was in the facility, she's only allowed to have $2,000, okay? From 130 to 2. It's not fair. There's no rhyme or reason about it, right? It just is what it is. So even when I sit down with folks that are like, oh, we're in the 130, I'm like, hold on a second. Because if one of you goes, we don't want to lose 128 grand, right? So even though they were in the green, it was only because they qualified as a married couple. So single individuals like myself, I've got to protect everything over 2,000, right? All right. Next, they had investments of $275,000. This is where Mary started to shop around to different attorneys. She was told by her lawyer that she would have to spend the $275,000 on mom's care And then that after 5 years, mom could get Medicaid. And I said, hold on, I know that's not right, because even if that 275 was over the limit, right? Even if mom's not allowed to have that, that doesn't result in a 5-year penalty. So first we said, okay, Mary, fill out the asset protection worksheet. I need to know how this money is invested. I need to know if it's an annuity, if it's an IRA, if it's cash, a CD, stocks. All of those items are treated differently under Medicaid law. And so she filled out that form, and we realized that those were annuities and retirement funds, which are exempt, okay? So she was initially very frustrated, and she said, well, why is one attorney telling me one thing and you're telling me another? Well, this is what we do every day. Asset protection, Medicaid law, and that was an exempt asset. And her lawyer that she had consulted with before that just didn't know. He wasn't aware that that was an exempt asset. He didn't know how he could protect it. So long story short, we were able to get Mrs. Smith on Medicaid, which meant for this family that $10,000 a month was capped at about $2,100. They just had to contribute her Social Security and a bit of their income versus $10,000 a month. Now, let's talk about the 5-year rule. Did Mrs. Smith wait 5 years? No. She still went through the look back, but when they looked back, they said, you're allowed to have the house. You're allowed to have the cash. The car is okay. Your investments are structured properly. So what I want you to understand is that even though we go through the look back, the penalty is not necessarily 5 years. And let's just assume, for argument's sake, that stock and investment was cash in the bank. She's not allowed to have that, right? So if that was her reality, her penalty is actually 275 divided by 10, which equals 27 months, okay? So even where you have too many assets, you very rarely wait 5 years, because even where she would have had 300,000 too much, she would have only had to wait 2 years and a couple of months. So that's another issue that we see, is we will see families say, hey, we moved mom's money 5 years ago, and this is how much we moved. We're ready for Medicaid. And I'll say, yeah, you're gonna qualify, but guess what? You qualified 2 years ago. And so you've just been paying out of pocket for 2 years. And having those conversations, you know, they're like, where can we get our money back from? You can't. So it's really important to be proactive about this, okay? And just understand the scenario, even if it doesn't apply to us right now. Go ahead.
Where do insurance policies?
Sure.
With cash value insurance.
Yeah, so cash value, cash that your creditor and predator can take from you. So that's a red line item, okay? There's a way to protect that, and I'll show you that with the trust, but insurance policies with cash value, you can think of that as just cash in your bank account. Go ahead, sir.
You own a house.
Yes.
Your children are added to the deed. Does that have a measure of protection for the, you said it's exempt in Florida.
Right.
I'm thinking New York again.
Yeah.
If you have a shared ownership, how does that?
So, sure. So yes, I'll repeat the answer. So if you have shared ownership, is that good? If your kids are on the deed to your home, is that good for Medicaid purposes? The answer to that is going to be that it really depends on the state that you're in. If your state, if you're a single individual and your state does not allow you to have a home, they could still assert a lien on that property. And in terms of probate, so having your kids on your deed is only going to help you in the sense of probate. It's going to help avoid probate. However, it also opens the door for you to be, your asset is now liable to your kids' creditors, or if your son or daughter has an accident and they get sued, or if they get divorced, whose assets are on the line? Yours. So in terms of Medicaid and asset protection, not advisable, but a lot of people do it for probate purposes. So we try to show a way to be able to accomplish the same thing without having that liability open.
So, based on that question.
Yeah.
So we all live in Florida.
Yes.
We own our home here. We don't, it's protected here.
It is.
So it would not benefit anybody to split it with their children in New York if it's protected in Florida and you're in Florida.
Correct. From an asset protection perspective, it's not going to benefit you to put them on that deed. No. So we don't want to do that.
The question now is, did they hear the question on the, and
So the question, yeah, the question was, so the question was, since you live in Florida and since you all own homes in Florida, is it beneficial for you to place your children from a different state onto your deed? For asset protection purposes, no, it is not. A lot of people do it to avoid probate, but again, it's not the best way because what you're doing is, yes, you're avoiding probate once you pass away, but you're still exposed while you're living. So what we're going to show you is how you can avoid that with a ladybird deed or with a trust. Okay. All right, so this is just another case study. So let's just do this very quickly. This was the Richards. They again came to our office. They said, look, we had to deal with one of our parents in long-term care and we saw what happened to their assets. It was depleted their assets were depleted very quickly. And so they wanted to just be prepared. So their game plan before coming to our office was to put everything into their daughter's name. All right. And so let's back it up 1 second. Mrs. Smith was allowed to have all of this, right? But if she had gifted any of that away, that would have incurred her a penalty. So just because you're allowed to have an asset under the Medicaid law does not mean you can give it away. Medicaid doesn't care if you spend $5,000 at the casino, but if you've given it to the Girl Scouts or you've gifted it to your grandchild, they're going to penalize you for it. So has to be tied to you. We can't be generous to the, a lot of clients will say, well, can I make a contribution? No, you can't. You need to do something first before doing that. So the Richards wanted to put this all in their daughter's name. First off, it's going to incur a penalty. Second, now it's the daughter's asset. So any of her liabilities, that money's gone. If she gets divorced, that money's gone. Okay. So just because you have a joint owner on your account, it doesn't mean that they own half of it. It means they own all of it. Okay. So if you are on any of your children's accounts, I really encourage you to get off. You can be their power of attorney. You can be their healthcare proxy, but there's nothing more heartbreaking than when I have a sick client needing Medicaid and now Medicaid wants the kids' money because mom was on the account just in case. Your kids should not be on your account either. That's a little bit less of a risk because it's your money if something happens to you. But if you're on their accounts, definitely change that after you leave here today, okay? All right, so these folks, they had a house. We can have a house, right? Medicaid's not gonna look at that. They had cash. Remember, we're only allowed to have $130,000 in cash, so they were over the limit a little bit. They have cars. We can have our cars. You can have a new car too. Go ahead. For a couple, and then for a single individual, $2,000. Yep. And then stocks and investments. So remember, we have to know how these stocks and investments are structured. So the whole takeaway here is they have a bucket. How much of that bucket is immediately protected? About 85% of it was, okay? So we knew that Medicaid could not touch 85% of their money. The rest of it was not safe, but remember, they're healthy. So we were able to implement an asset protection plan for them. So that's where I keep talking about the trust. The Richards were able to place their assets into a trust that they controlled, all right? And the money that was not safe, every month, more and more became safe. So I'm gonna segue into the trust that's gonna protect you, and then I'll distinguish how it's different than other trusts that you might have dealt with in the past. All right, so how do we protect our stuff? We do it through the right trust. Before we get into which one it is, let's just talk about what is a trust. I want you all to think of a trust as a box. Whether that box is open or closed or there's a trap door, it's a box. And when you have a trust, you want to make sure your stuff is in the box. So another one of the biggest mistakes that I see every day, clients will come in, they'll show me their trust. I'll say, what's in it? And they'll say, well, I don't know. I don't know if my assets are titled to it. And the best is when the lawyer who drafted it stapled a dollar bill to the back. That's my favorite when I see that. I'm like, what have they done, right? So understand that even if you have an open box, which is the revocable trust, we'll talk about that in a second, but even if any trust that you have, the rules in your trust do not apply unless your asset is in the name of that trust, okay? So let's say my name is Claudia DeJesus, let's call my trust CDJ, okay? If my bank account isn't in the name of CDJ, if my deed isn't titled to CDJ, my rules aren't being followed. So we make sure that every trust gets funded. So when you have a trust, when you have that box, you have three parties. You have the grantor, that would be all of you. That's whose stuff it is, right? Your house, your cars, your assets. You have the trustee, that's going to be all of you, okay? Why? Because you want to be in control. And then you have your beneficiaries, and that's going to be whoever you want it to be, okay? The trust that we create, we encourage our clients to always be the trustees, and we always want to keep them in control. But of course, what are we going to talk about? Having your backups. So let's talk about which type of trust is proper. The revocable trust, that's your open box. We call it an open box because guess what? If you get sued, if you need Medicaid or long-term care, your stuff is going to fall out, okay? In a revocable trust, your assets are not protected. Why? Because in the revocable trust, you are allowed to control by yourself. And it's a long-standing notion in the law that where you control alone, so can your creditors and predators. So what's the point of a revocable trust? Well, many people have it because, first of all, you can set those rules for your family members once you're gone. Second of all, it avoids probate. So the way that I want you to think about it is that your revocable trust, your open box, gets you 3/4 of the pie, all right? But we're leaving on the table asset protection, right? Irrevocable, everyone starts to freak out, similar to the word Medicaid. In irrevocable trust, think about it as your closed box, okay? A lot of times, people were trying to avoid estate taxes with an irrevocable trust. And so when they would hear irrevocable, it meant appointing someone else to control, which is not convenient, right? And it meant that that trust was its own entity, and so it paid taxes, all right? That is not the trust that we're going to talk about protecting you. And so what I want you to remember is that there's hundreds of trusts out there. They're all very different. It all has to do with how they're formatted. The trust that allows you to control and protects you from Medicaid is what I want you to think of as the trap door, all right? Not quite open to leave you exposed, not quite shut where you don't have control. We got the trap door. So how is it that you're able to control assets and still protect them? You cannot control by yourself. So in an asset protection trust, you have to control with someone else. That can be your spouse, or for my single folks, that can be a loved one, whether it's a child, a friend, whoever, okay? Once you have your asset protection trust, you want your assets in there. So for example, if we have $500,000 and we want to make sure that that's protected from Medicaid, we need to make sure that our bank accounts are in the name of this trust. We need to make sure that our brokerage accounts, wherever we have those things held, that they're properly titled. In the asset protection trust, even though it's classified as irrevocable, it's tied to your social security number. So that just means no extra taxes. And you're always in control and you have the power to change. So you can change who your beneficiaries are. I want to show you how this trust works. So do I have any volunteers that would bravely volunteer for me? What about my couple from Buffalo over here? Buffalo and Chicago, right? Yeah. Okay, perfect. So, well, first of all, tell me your first names. Mary Jane. Oh, okay. I'm sorry. What was that? Okay, perfect. So Mr. and Mrs. Brancato. How many years of marriage? Amazing. And so what is the secret? We're writing a book. What is the secret to 56 years of marriage? That's the secret, right? Okay, so, all right, so let's say you come into my firm and you say, hey, we want an asset protection plan. And now, did I hear that we have a blended family? Did I understand that right?
No.
Okay, so do we have any children?
Yes.
All right, how many? Two. What are their first names?
John and Patrick.
Okay, perfect. All right. So, Mr. and Mrs. Brancato, when you come in for an asset protection plan, we're going to put your assets into one of those trap doors, okay? And who's going to be in charge of that trust?
I'm assuming both of us.
Exactly. That's right. And so John and Patrick are going to be the beneficiaries, right? If they act properly. If not, you can change that at any time. So when you're controlling your trust, if you want to go out and let's say purchase a new condo back in Chicago because you miss it, can you do that? Yes, absolutely. You've got control. And Mr. Brancato's like, great. And so, and if you want to go out and buy a new car, can you do that? Yes. Okay. You're going to be in control. And so now, Mr. Brancato, only because we get rid of the men first, but we're just going to send you to heaven for a second. We'll revive you in a little bit. Now, if your husband's gone, can you control your trust alone? No. You can't. That's where the asset protection comes in, okay? If you want to protect the asset from lawsuits, we always have two people in charge. So Mrs. Brancato is going to choose which one of your lovely boys? John. Yeah, exactly. See, I know, we always get a bad rep. So, okay, so John is now going to control the trust with her. Now, is it John's money? No, so he's never a grantor, which just means that if Mrs. Brancato wants to renovate that condo and John says, Mom, I think that's a useless point of spending your money, she can still do that. She doesn't need John's permission. If John upsets her, she can fire him and appoint Patrick, okay? So when it's your asset in the trust, you have ultimate control, all right? Now, when you pass away, if both of you are gone, what's nice about having a trust, an asset protection trust, is that you're going to be able to leave one for John and one for Patrick, okay? Imagine your trust branches off into two. So what does that mean? That means that if John's wife or John's spouse leaves him, they don't get any of the assets you've left him, okay? Once he's gone, it's going to flow to your grandchildren or wherever it is that you'd like it to go. So that's how nice and clean a trust can be, okay? And then God forbid something happened to John, you know, the Brancatos don't have to go back to an attorney. Why? Because when they initially created the trust, that was all planned for. It's already written in there that it will go to their grandchildren, or it might route back to their son, Patrick. So that's the point of having a proper planned estate plan. Yes.
So my question is, if you have to have two.
Yes.
Now the Brancatos are not here.
Correct.
It's split between the two sons.
Yes.
Do they need to have a second person?
Yes. If they want asset protection, they need to. So, great question. So, when you have a trust and it branches out, do your beneficiaries need to have two trustees? And the answer to that is yes, if they want to preserve their asset protection. So what's written into the trust is instructions for John and Patrick, and it would essentially say, you need to select a co-trustee. Now, the way that we do this is they are not allowed to select their spouse as a co-trustee. Why? It wouldn't give them the divorce protection. And so let's say that they wanted to protect John from himself, right? They could still leave John 50% of the assets, but have Patrick control it. So you can never control a loan when you want to protect from creditors and predators. That was a great question. Thank you. All right, back to life. Thank you for being my volunteers. So just remember, yes. Sure. So the taxes are tied to you. So what's your first name, ma'am? Susan. So when Susan files her tax return, her trust has filed its tax returns. It's all tied to you. So whether you get something that says Susan's trust or Susan, it all flows nicely. And in terms of being income producing, it is, because when you have a trust, the way you want to think about it, as silly as it is, it's really just a name and the papers that go along with it. But that's going to make all the difference. So when your Fidelity account is in the name of Susan's trust, it's still producing income, but it's still protected. Does that make sense? And so you can have annuities, you can have cash value life insurance in there in order to protect that asset, and then you'll still be able to take your income, spend your money how you'd like. It has to be in the trust name, yes. So let's say we called yours LT Trust, right? You want to make sure every statement you get is Linda Taylor, trustee of LT Trust. Remember that your trust is your rule book? Yes.
Curious, just going to go back to the long-term care.
Yeah, absolutely.
That's one of the preferences. If you have long-term care insurance.
Yes.
That's a whole bunch of money that's going to go pay that $10,000 a month.
Yes.
Fees are. It seems that if Medicare is going to jump in with such a really low bar, why spend all this money on long-term care insurance?
Well, so here's what you want to understand about your long-term care insurance policies. They're great, and if you have them, that's fantastic, but you want to understand how much it covers, because right now the cost of care is nearing about $400 a day, and most policies only cover about $150 a day. So you might have one of those rare, great policies that they don't make anymore that cover a ton, and that's great. For you, your, the revocable trust might be great in that scenario, but most people don't have long-term care insurance, and if they do, they still want to have protections in order to make up for the deficit. Yes, yes, I see it here. Okay, great.
From Dr. Bruce Gerber, he says, what is the advantage of having your trust own your home?
Absolutely. The advantage of having your trust own your home is, first of all, you're going to avoid probate, and you're still going to keep your homestead. So don't think that because your house is in your trust, you're losing your homestead, okay? So you're going to avoid that probate, and here's the advantage. Let's say Dr. Gerber goes into long-term care, okay? If his house has been in his trust, and he's no longer living in the house, and his kids want to sell it, now what's going to happen? The house that's in the trust is going to sell, and the money is going to go where? In the trust, where it's protected from the cost of long-term care. So that's one of the main strategies of putting the house into the trust, is being able to take that asset and make it liquid without losing the liquid. And then also, of course, avoiding that ultimate goal of probate. Okay. All right, so when we talk about the cost of probate, it can be very high. It's almost 3 to 5% of your assets. So we definitely want to avoid that. The cost of long-term care, $120,000 a year. We definitely want to avoid that, right? So we want to make sure that we've got an estate plan that addresses these issues. Maybe you don't need an asset protection trust. That's fine. But we're going to spell out for you if a will plan is proper, if an open box revocable trust is proper, or if the asset protection trust is the way to go. All right. So a lot of folks will say to me, I have my revocable trust. Remember, not every trust is the same. So that's the open box. The Medicaid protection only applies if you've got a closed box or a trap door. All right. So there are differences in your trust. Okay, so we're here to protect your financial freedom. We want to help you review and understand what you have. So if you do have a long-term care insurance policy, we're happy to review that. And you're welcome to bring all of those tools to your vision meeting. All right. So The last step of having any type of estate plan and trust is, again, making sure everything's properly titled. So going back to Dr. Gerber, going back to what Linda was saying, the last step of your planning at the Mattar firm, we will fund your assets for you. So we're going to make sure your house is in your trust, that your accounts are in your trust, all that good stuff. All right. And then, of course, remember, even though it's classified as irrevocable, you can still change who benefits. You can buy and sell. So just because you place your house into the trust doesn't mean you can't sell it later. Okay. You have control over your assets. All right.
I have a question for you that irrevocable.
Yes.
So you have a house
Yes.
and you put it in your the names of your children.
Yes.
And it's just irrevocable trust.
Okay.
You have a falling out with one of the children. It can't be changed. Is that correct?
Well, if you have an irrevocable trust that was structured that way, yes, but not the one that I'm talking about. But you might have already an existing irrevocable trust where if you don't have the consent of your trustees, yeah, you're in a pickle, right? And so that's the benefit of the asset protection trust, is that you're the trustee. So even if the relationship goes south with any of your beneficiaries, you can change that. They don't treat you nice, you off with them, right? Yeah. Okay. Yeah. So yeah, that's one of the benefits of being in control. Go ahead.
The proceeds of life insurance.
Yes.
Upon death,
Upon death.
sheltered in any way?
It doesn't, those don't have taxes, but again, sheltered in what sense? So for example, if you, yes. So if you, this is a big one as well. Let's say you and your spouse qualify for Medicaid because of the 130, but now let's say that you have an insurance policy that's going to pay out upon one of your deaths. If that doesn't go into a trust, let's say it's 250,000, right? So you pass away. If your spouse is in a nursing home or an assisted living, and that insurance policy pays out into their bank account, that's at risk. So that's again why we want to, when you have a trust, if it's the right one, you want to route everything in there, because if you're gone and that insurance payout is coming, you want to make sure that's protected as well. So, and then without a trust, the only protections that has is just that it's tax-free money. Okay. All right. So Rockefeller said, and one of my legal assistants disputes this with me every time, but it said that Rockefeller said, own nothing, control everything. So the way that you want to think about it is that everything is in that trust that you're controlling. But for purposes of asset protection and your creditors, you want that to be in your trust because you want your liabilities to be separate from those assets. Okay. All right. So I forgot to make my promises, but I hope time went by quickly. I hope that you've learned a lot. I'm going to turn things over to Anna Lee. And also, each and every one of you is entitled to a free consultation with our office. Those online, we're going to be reaching out to you tomorrow. My legal assistants will be calling you. And then those here in person can make an appointment with Ashley. And then I'll open it up for any questions before I turn it over to Anna Lee. Thank you. Thank you. Sorry if I seem a little out of breath. It's been a year since our last live in-person presentation. It's a pleasure. The only thing that will not go into your trust while you are alive are your retirement accounts. Your retirement accounts can only be in your name. So even if you wanted to put them in your son's name or your husband's name, whoever, you can't. Those can only be in your name. But remember, those are a protected asset under Florida law. So even if you have $1 million in an IRA or a 401, that's fine. Even if it's in your name, it's still safe under Florida law. So that is the one asset that will not go into your asset protection trust.
If it has a mortgage on it.
That's okay, because yes, it's protected from creditors, but except for the house to the mortgage. So it will still be subject to that lien. Yep. All right. Any other questions? Yes, ma'am. Yeah.
together. Now, the 130,000 has been protected.
Yes,
As soon as they're not a couple, because they can't be a couple,
right.
she has to then, does she give them the opportunity to replace, not another husband, but
Yes. So remember, the 130,000 rule only applies when you don't have that trust. That just applies, that's what you could have outside of the trust in cash. So in that scenario, yes, she would have another backup co-trustee. So maybe it would be Patrick or someone else. And then the really interesting thing that we didn't get into with the Brancatos is that when you have a trust, you can set remarriage provisions. So let's say Mr. Brancato's gone and Mrs. Brancato's like, the pool boy is looking really nice, right? And so you can set into your trust that if you do remarry, that half of those assets are now protected for the kids. So that's a really popular provision as well, that folks like to throw in there to keep honest people honest, as I say. Go ahead.
If I pass away, I need life insurance.
Yes.
And Medicaid, kind of claim some of that as part of that payment for services they provide?
No, because that life insurance is now either going to go into your trust, or if it goes directly to your family member, it's no longer your asset. So Medicaid cannot claim an asset that is now someone else's. So the answer is no, they cannot.
That's assuming you have a beneficiary designation on the
Precisely. Yes, thank you very much. If you don't have a beneficiary and that life insurance money goes to probate, then yes, Medicaid can claim it. Sometimes folks forget to put beneficiaries on their policies, or they'll put the estate of, and anytime that you have the estate of, that means that your family's going to probate. So that's why when we meet, you're going to see that I have a list of goals. And at the top of my goals for you is always probate avoidance, because it's just terrible. Go ahead.
retirement account with the beneficiary.
Yes.
Are they probatable?
If there is no beneficiary, if that beneficiary dies, and
You have a beneficiary.
then no, they won't go through probate. Correct. Correct. All right. I think,
One more question
Okay.
online here from Dr. Gerber again. It's on my death, does my IRA roll over into my spouse's trust without taxation?
yes, it will. So because this is a pass-through trust for tax purposes, you can either leave the IRA directly to your spouse and have your trust as the contingent beneficiary, or you can leave your IRA to the trust, in which it will still go to your spouse and be protected and have all of those tax consequences or benefits. The reason that we sometimes say just leave it directly to the spouse is because it's going to continue to be a qualified asset, and so it'll still be protected under the law. Yes, sir.
Question, how many states share the same laws as far as all of this?
Every state is different when it comes to Medicaid law. So every single state has their own numbers. Now, the trust, that can be used in all of the states, right? And so that, if you establish it in Florida, if you move back home to Michigan or to New York or Indiana, that's fine. It goes with you. So the whole point is, if you don't want to worry about those nuances in the law, then we have to do some proper asset protection planning. Okay. All right, I'm going to turn it over to Anna Lee. Yay. Thank you so much for having me. It's been a pleasure.
I always learn so